All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for Protecting Florida Homeowners' Rights, a legal analysis of the rights of homeowners living under an HOA or a condo association in Florida. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you're registered, you're going to receive a copy of the recording from Zoom within about 24 hours. We will also include a link to the materials as well. I'll drop those in the chat as well. You will also be able to find it on YouTube. We will post it on YouTube, and all this information will be included in the description. The training was approved by the Florida Bar for one general CLE credit, one condo and plan development law certification credits, and one real estate certification credit. I'll announce that CLE code towards the end. I will drop it in the chat. That code will also be included in the YouTube description and in the email that goes out from Zoom, so you're not going to miss it. Closed captions are enabled for anybody who needs them, so if you're having any issues with accessibility, let me know in the chat or feel free to email me directly. I'll drop all of that information in the chat as well. The training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, I'm going to drop some information about our section into the chat as well. Feel free to take a peek at our group and our working group. And final piece of housekeeping announcements are questions. If you have questions during the webinar, please use the Q&A feature instead of the chat. It's going to be a little bit easier to track. Our speaker has saved some time towards the end of the presentation to address any pending questions. So feel free to use that feature if you have any questions. So with all of that said, it is my pleasure to introduce our speaker today, Erik Perez. Erik Perez is the co-founder and shareholder of Perez Mayoral PA. He leads the firm's Homeowners and Condo Association Litigation Practice Group for general association disputes. As head of this practice, he focuses on representing homeowners and unit owners in their disputes with associations, leveraging his extensive litigation experience and comprehensive understanding of association operations to advocate effectively for his clients' interests. So it is my pleasure to pass it over to Erik Perez. Erik, the floor is yours.
Hello, everyone. It's a pleasure to be here and to present this information. I'm very much looking forward to providing you with insight as to how to navigate these HOA and condo disputes. Thank you for the introduction, George, and once again, thank you for this opportunity. So without further ado, let's go ahead and jump into the presentation. Once again, welcome and thank you for joining. Today's goal is to really help all of you understand the basics from the attorney's perspective on how to handle the bulk of these HOA and condominium disputes that so many attorneys in Florida come across. There's a lot of litigation, a lot of issues that arise between homeowners and associations, and pretty much any attorney practicing in the state of Florida at some point will definitely come across some of these issues. My understanding is many of you come across these sort of issues and want to get an understanding of how do we navigate these issues? What questions should we be asking the homeowners in these sort of situations? So I look forward to providing you with insight as to all of this. Briefly, today's agenda will be split in the following manner. The first thing will be understanding the basics, understanding HOAs and condominium associations. The second will be jumping into the common disputes, things that we see on a daily basis. The third will be how to protect homeowners' rights. What actions can you take? And the last one will be questions and answers. Now, as George provided, I will definitely try to have even more than 5 minutes for the end for Q&A. Don't worry about putting your questions in the chats. I'll make sure to answer as many questions as possible. And if I don't get to your question, please feel free to email me. You'll see my email at the end. You can email me directly, whatever your question is. If you'd like an email response, I can provide you with an email response. If you'd like to have a telephone conversation and kind of discuss the issues that you're seeing as it pertains to an HOA or condo matter, please feel free to give me a call. Happy to answer your question. So don't worry if you don't get it answered today. Your question will certainly be answered at some point in the future. So understanding HOA and condo associations, I think it's important to give a brief history. You know, history answers so many questions about the law and gives so much context. And I think that it's important to understand a little bit about the history of condos and HOAs. Okay, so HOAs first came out in the early 1900s. In the 60s and 70s, there was rapid expansion through suburban development. And today there's over 370,000 HOAs in the US, covering about 40 million households. Florida is actually number 2 in the country for HOAs behind California. Pro rata, Florida is actually number 1. So based on the amount of people, Florida is number 1 for HOAs. Condominiums, similarly, first came out in the 1950s. In 1961, Utah became the first U.S. state with condo laws. In 1963, Florida passed 718, which is known as the Condo Act. And today, about 28% of Florida households live in condos. That number is going up daily. As you can imagine, with all these buildings going up in the Brickell area, in the downtown area, and the Doral area, that percentage is going to continue to increase as the years go by. So some of the basic things that apply within the association context, and it is important to have a general legal understanding on, is number one, what do you own when you own in an HOA in a condo, and how is it different? Okay, these are the key differences that you see currently on the screen. In an HOA, essentially you own the land, okay, and the home, the structure on it. Okay, within, and we'll talk about this further, within the HOA context, there are different types of area. There's homeowner property, there's limited common areas, there's common areas. So a lot of different types of properties within the association context. But what do you own when you're an owner in an HOA? Well, you own the land and the structure on it. In a condo, a little bit different. What I like to tell clients is you basically own a piece of space in the sky when you own a condominium unit. Okay, you own the interior of the unit as defined by the declaration. Typically, the language you will see on declarations is the unfinished drywall inward. So basically, the paint inward is what you own within a condominium association. You don't own the community pool. You don't own the lobby of the building. You own solely the unfinished drywall in, generally speaking, depending on what the declaration provides. Okay. What is the governing law? This can answer about 70% of the questions any attorney may have within the HOA and COA context. So if you don't know where to start and you have an HOA issue, best starting point, Chapter 720. Okay, go to the Florida legislature's website, look up Chapter 720, known as the Condominium Act, and that has a good probability of at least giving you guidance on what is the general framework as it applies to the homeowner's legal situation within the HOA context. The supplement to that are the CC&Rs, the covenants. The covenants are recorded in the public records of the county and are a contract between the homeowners and the association and all of the other homeowners that live in the community. Okay, so all of the neighbors are contractually bound by the language that is in the covenants of that association. So if you're facing an issue, you have no idea how to respond to the homeowner, you have no idea where to begin the search for the questions that are being posed or the factual scenario that you're being faced with, look at Chapter 720, look at the CC&Rs of the association. Sometimes the owner will have it. If they don't, you can do a quick public records search using the property appraiser's website for the county that the property is located in, and you will be able to find ultimately the covenants of that particular association. Condominiums, a little bit different. Chapter 718, known as the Condominium Act, are what governs disputes within condo associations, okay? Similar to Chapter 720, 718 has many of the provisions that are almost the same. There are some very key distinctions, more on that later, but 718 is very similar to 720, and 718, as I mentioned earlier, can answer about 70% of the questions that you face as it pertains to a condo legal situation. Okay, to supplement Chapter 718, every association must have a declaration of condominium, which works just like the covenants under Chapter 720. The declaration of condominium is a contract between the homeowners, the association, and all of the neighbors. Okay, common areas, as I alluded to earlier, are very different within the HOA and COA context. Common areas in an HOA include roads, parks, landscaping, clubhouses, fencing. Basically, anything that is beyond the sidewalk, generally speaking, is a common area or common element within the HOA context. In, slightly differently within the condominium context, you're looking at very different common areas. You're looking at the exterior walls of a building, the roof of a building, the stucco, sometimes the balconies, sometimes the plumbing and the wiring. So when you're thinking about HOA versus COA, generally what you're talking about is within the COA context, you're often talking about a building, although sometimes it can be townhouses and become a little bit more nuanced and unclear whether it's an HOA or COA. The governing documents should always provide the answer to that question. So if a client comes to you and it's a townhouse and technically it's a building where multiple people live in, the client is unsure whether it's a COA or an HOA, you can look to the governing documents, either the covenants or the declaration of the association, to identify under what chapter of Florida statutes the development, the association, is organized under. And as I mentioned, Chapter 720 and the covenants will answer your question if it's an HOA. Chapter 718 and the declaration will answer your questions if it's a COA. Okay. Maintenance obligations. It's important to note that generally speaking, the homeowner in both contexts is responsible for their property. The association is responsible for the common area maintenance. Insurance, HOAs are often have insurance for the common building, for the common property areas. As a matter of fact, I believe Chapter 720 requires it, just like Chapter 718 also requires it for maintenance or for any sort of casualty related event in the common areas. So they basically both have to have property insurance. HOA is responsible only for what is required to maintain under the governing documents. Owners are liable for damage caused by their own property. So much like the car accident cases, if your car crashes into someone else, you are liable. So if your unit has a leak that spills over into the common areas, as a homeowner, you may be liable to the association. Conversely, as an association, if you have a common element pipe or a roof that leaks into a condominium unit, the association may be liable for those damages. Alterations and improvements. Generally speaking, rule of thumb, if a homeowner is asking you whether they can make a certain alteration, rule of thumb is you should definitely run it by the association. What you're talking about here is oftentimes limited common areas, and every association's declaration, whether it's HOA or COA, the covenants have different procedures for alterations and improvements. For the most part, as it relates to common areas, a homeowner cannot make an alteration to a common area. So, let's say you're a big fan of jacuzzis, your condominium association doesn't have a jacuzzi. You can't just go ahead and install one near the community pool or near the community gym. That belongs to the association. That's common area. The homeowners have no say over that. Okay, but let's say that you want to install one on your balcony, or you want some sort of above ground pool in your backyard in an HOA. You may have the ability to do that depending on what the governing documents provide. However, for the most part, you're going to need association approval before making those sort of changes. Many homeowners get into issues related to that because they don't submit the proper paperwork to the architectural committee of the association. More on that later. So as I mentioned, the most important thing, look at the covenants in an HOA, look at Chapter 720 in an HOA, look at the bylaws, look at the rules and regulations. All of these things must be recorded in the public records to be binding. So make sure that you're not taking the association board member's word for it. You're not taking someone else's word for it. It's got to be written into the rules of the community, and they must be recorded in the public records. Same thing in 718. The declaration must be recorded in the public records. Make sure it's in there, and look at 718 in the condominium context to make sure that the association is complying with the statute. Oftentimes I'm asked, what is more important? Is the declaration or the covenants more important than the statute, or vice versa? The answer to that question can become very tricky as a result of what's known as Kaufman language. But generally speaking, what is in the statute prevails over what is in the covenants or the declaration of condominium. If the declaration of condominium has Kaufman language, it may invert the analysis. So that's a little bit of a kind of nuanced part of association law as it pertains to amendments in the statute and in the governing documents. You would have to evaluate whether there's Kaufman language. But generally speaking, look to the statute first. If it doesn't answer the question, then look to the covenants. If there is a point of conflict between the covenants and the statute, generally speaking, what is in the statute should prevail. However, you may need to do the Kaufman analysis. What can associations do and not do? Well, they can collect assessments, they can enforce the rules, they can issue fines, they can manage, as I mentioned earlier, common areas. What they can't do, they can't completely ignore maintenance. They can't what's called selectively enforce the rules, which is a form of discrimination. You get this call all the time. Hey, my neighbor has this water fountain. I loved it. I bought it. I submitted an application. They never answered it. 3 months went by. I decided to go ahead and install it. I just received a $1,000 fine. Why can my neighbor have the fountain and why can I not have the fountain? Well, that's called selective enforcement. Associations cannot selectively enforce the rules on one homeowner and not another homeowner. However, the homeowner does need to document that sort of evidence. They need to gather photos, videos, whatever evidence they have to support a claim for selective enforcement. Okay, they can't deny access to records. Oftentimes, issues come up with records. Homeowners have the absolute right under both 718 and 720 to demand an inspection of records. So the association, within, I believe, 10 business days upon being requested the records in writing, ideally you want to send those requests certified mail because it creates the presumption that the association is refusing to provide records. But even if it's just in writing via an email, the association must provide access to association records, and they absolutely cannot hold secret meetings. The only secret meeting they can have is with their attorney, and that's because of attorney-client privilege. For the most part, every other meeting must be held in the open. Okay. As an owner, I would say the list you see here is the way to resolve or to proactively try to resolve almost all issues. Demand, what I tell homeowners all the time is demand records, demand maintenance of the common areas, demand the ability to vote in elections. If you really want to take control of the community, become a candidate for the board in the elections. Okay. And these are all very key ways to try to avoid issues within the association. So briefly, some developments in Florida law. Because of the Surfside collapse, there's been many changes in legislation, particularly as it relates to safety and the structural soundness of buildings. Key takeaway from this is living in a condominium in the state of Florida is more expensive now as a result of the changes in legislation. The legislation obviously intended to make buildings safer, but it has also concurrently increased the cost of living within condominium associations. So it is not uncommon to face special assessment issues. It is not uncommon to face structural integrity reserve issues. And homeowners, when facing any sort of assessment related issue, should be aware, hey, I understand that they passed a special assessment. This is becoming more commonplace because of the legislation. And specifically, it was triggered by Surfside. The legislature wants to put mechanisms in place to make buildings a little bit safer, and that's driving up the cost of living in these communities. So common disputes, okay, and I'd like to start off with a very briefly an interesting story. So we're going to be talking about the things that most of you will come across. There are very unique things, such as I had a call the other day where a homeowner went on a cruise, for the summer, a week-long cruise, which is not uncommon, of course. Many people go cruising over the summer. And fortunately, this homeowner had a Ring camera, and he caught the board members and the maintenance people having a party in his backyard. He had a very nice backyard with a pool. They snuck in and decided to have a little party in his backyard. Similarly, within the condo context, I received a call last week where a homeowner, a condo owner who lives in a condominium unit, was at home, using the restroom, and unbeknownst to him, the association wanted to do a random inspection of his unit. Went in, they didn't know he was in the restroom, and essentially watched him using the restroom. Very uncomfortable, as you can imagine, for the homeowner. But this stuff happens. We won't be going too deep into that. We'll be talking about the more common things, but don't be surprised if you're faced with very dramatic issues like those within the association context when you receive a call from a homeowner with an HOA or COA dispute. Assessments. So assessments are a very hot topic within the association context. These cases are very, very difficult. Okay, there is a playbook for attacking them, but they're very difficult to resolve in a way that is ideal or exceptionally favorable for the homeowner. Okay, brief background on assessments. There's basically two types of assessments: regular assessments and special assessments. Regular assessments are where you pay as a homeowner to cover the operating costs within the community. Sometimes you pay them monthly, sometimes you pay them quarterly, sometimes you pay them yearly. Okay, for the most part, as long as a homeowner is paying them, they're not going to have any issues with regular assessments. From year to year, as a result of the increasing budgets, they may go up. It's not uncommon to see maybe a 5, 10, maybe even as high as 20% increase in regular assessments. The price of everything in the world is going up, particularly in Florida and particularly in South Florida. So it is not uncommon every year, someone's maintenance may go from $250, $300 a month, may go up to 400, 450 from one year to the next. So that's not uncommon. Homeowners can end up in a foreclosure case if they don't be sure to pay their regular assessments. There are not many defenses in those types of cases. So if a homeowner is contacting you with regards to regular assessment related issues, for the most part, the advice is going to be, hey, they can tack on legal fees, they can tack on interest, they can tack on late fees. None of these look outrageous. You may want to consider paying it because the issue can only get worse. Conversely, special assessments do have statutory mechanisms in place before they can be passed. Okay, you need proper notice to the owners. Okay, sometimes it needs to be voted on if it requires a material alteration. So there are more statutory mechanisms in place to fight special assessments. But when it comes to both of these, and we're going to go into this a little bit deeper now, but when it comes to both of these, generally speaking, as it pertains to regular assessments, you need to fight them procedurally. Did the association comply with all the statutory procedural requirements as it relates to notice, as it relates to timing of the notice, as it relates to what's contained on the notice? So you can fight these procedurally. Keep in mind, the harder you fight, the more attorney's fees there are on the other side. And even though you may save a client some money, they may have to pay it on the back end because of the additional attorney's fees incurred by the other side. My personal take on this, I think the legislation needs to change as it pertains particularly to assessment foreclosure cases. I think homeowners need to receive better notice. I think they need to be afforded the ability to comply in a way where there's a payment plan involved. So a lot of changes in the legislation I think that need to happen as it pertains to special assessment. Similarly, you need to fight these from a procedural standpoint. Did the association provide the requisite notice? Did they do it within the requisite time frame? Did they explain adequately what the special assessment is for and where the money is going? So both of these, for the most part, need to be attacked procedurally. You need to look to the statute to see if the association has complied with the statute. They can be attacked substantively if, particularly special assessments, if the special assessment is for the purpose of a material alteration. That requires a vote. It's a big issue we come across very frequently. If the association is trying to install a new, as I mentioned earlier, community jacuzzi, or a new community gym or clubhouse, or for aesthetic reasons, they want to completely change, the clubhouse in an HOA context or in a condo context. Let's say they want to completely change the flooring and the interior, add more luxury furniture, more luxury amenities. That may require, depending on the language in the covenants, that may require a vote before they can pass a special assessment to force the homeowners to pay for those types of capital improvements. And so you need to look to the covenants and make sure that if they're trying to advance a material alteration through a special assessment, that there was a vote. Collections efforts and liens in foreclosure actions. So as I mentioned earlier, these are the basics. There needs to be a notice, okay, to the homeowner. Ultimately, the association can put a lien if they comply with the statutory framework. And lastly, they can foreclose. It's very sad. I've seen it many times, particularly with elderly homeowners, where they have no idea how this process works. They receive a letter in the mail, they throw it away. And before they know it, they have lost their home in a foreclosure, the home that they've lived in, the condo that they've lived in for 30, sometimes 40 years. And the way these people can be protected is by all of us here. They can be, when these types of clients reach out to us and they say, hey, I received this letter. I don't know what it means. It talks about a lien. Maybe there's a language barrier. Maybe they only speak Spanish. You need to let them know, hey, if there's a lien or an intention to lien your property, your home can absolutely be taken from you at a foreclosure. We need to take steps now to avoid this. That may involve negotiating a payment plan. That may involve taking out a line of credit or a home equity line to pay for this, to stop the association foreclosure. There's many tools out there. The sooner that you can have this conversation with the homeowner, the more likely you can avoid the foreclosure. Once the foreclosure sale has occurred, it is almost impossible to undo it. And sadly, many homeowners are losing their homes in the state of Florida because they're not contacting an attorney soon enough to discuss these sort of issues. If you have a homeowner that has a lien on the property, you need to tell them, hey, you need to immediately resolve this. You need to either pay it, get on a payment plan, or take out a line of credit. I know you're not happy with the attorney's fees. I know you're not happy with the interest. I know you're not happy with the late fees. Negotiate it as best you can, or hire an attorney to negotiate it as best you can and get it paid. And even on the back end, if the association did something wrong, you can absolutely sue them to try to get some of that money back and to try to get some of the attorney's fees back as well. But don't be in a posture where you could lose your case, you could lose your home at a foreclosure sale. Okay. Maintenance responsibilities, who pays for what? There's so much litigation over this, and there's so much confusion over this, not only from homeowners, but from associations and from attorneys as well. Okay, you're in your practice, you may come across situations where the attorney or the board of directors or someone on the other side that is not the homeowner is telling you, well, that's your property. Here's what the declaration says. It says unfinished drywall in is your property. And you got to fix it. It doesn't matter where the water came from. And that is so inaccurate and confusing. And once again, there's so much litigation over that. I like to give attorneys and homeowners an analogy that can help clarify how the maintenance obligation works. Okay. And as you can see on the screen, when we alluded to this earlier, unfinished drywall in belongs to the homeowner. If the homeowner causes damages outward of that, the homeowner is responsible. Okay. And of course, your own personal property. If you have a dishwasher, if you have a water heater that belongs to you and that leaks and causes damage to your property and other properties, as a homeowner, you may absolutely be responsible for that. Conversely, the association has the same obligations. Okay, anything with the building of the structure or the roof, the common area hallways, the shared plumbing, the shared electrical, the elevator, the pool, and any damage they cause, they are responsible for. Okay, the analogy I like to give in these situations is you have to think of your condominium unit in your association as your car. Okay, you're responsible for your tires, you're responsible for your rear bumper, you're responsible for your front bumper, you're responsible for your engine. Okay, that is unfinished drywall in. You're responsible for that as the owner of a car, you're responsible for that as the owner of an HOA or a condo. Okay, now if another driver crashes into your vehicle, let's say you get rear-ended by the other driver when you're driving on the street, and you get out of your car and say, hey man, my bumper looks pretty messed up. I'm going to need you to help me pay for the repairs. We're going to have to get your insurance information. And that driver tells you, hey, actually, your insurance policy says that your rear bumper is your responsibility. Why do I have to pay for it? That's your responsibility. Well, naturally, your response would be, well, I wouldn't have any damage if you didn't crash into me. Okay. And a lot of associations kind of use that logic when dealing with these property damage related disputes. They'll say, well, everything inside the unfinished drywall is drywall inward is your property. So I know that the leak came from a roof leak, but the flooring belongs to you, the drywall belongs to you, your kitchen cabinets belong to you. So you got to pay for that. We're not going to pay for that. That is absolutely incorrect. The association is liable for any damage they cause as a result of their failure to maintain the common areas. And so that can look something like the roof has a leak that spills into your ceiling and spills into your home. It causes damage to the kitchen cabinets, causes damage to the flooring, causes damage to your appliances. That is not the homeowner's responsibility. That is the association's responsibility. Sadly, associations will not do anything for the most part, in my experience, until you sue them for those damages. Okay. The good part, my firm and sometimes other law firms take these on a contingency fee basis. So the silver lining is that there is an ability to recover without having to come out of pocket and pay for an attorney. But let your homeowners know when you come across them, hey, if the association is telling you that you need to fix that, even though the water came from something they are responsible for, they are wrong. They need to fix that. If you need to fix it yourself immediately, make sure to save the invoices. Make sure to send them to me or whatever attorney you decide to hire for the dispute, and we will work to recover the damages as it pertains to any sort of out-of-pocket expense. If you can't afford to pay for it, make sure to get an estimator or loss consultant, someone that can go to the property, give you an estimate, and that estimate can be used to sue the association for the damages they have caused. These are common problem areas as it relates to maintenance. So water leaks from units above. Sometimes it's not the association. Sometimes it's unit owner versus unit owner. You can have, as I mentioned, a washing machine leak, a water heater leak. You can have a refrigerator leak, a bathtub overflow leak. So if it belongs to the upstairs neighbor, and that person caused the damage to occur to your unit and you are the downstairs neighbor, that unit owner may be responsible. Okay. Common area pipe bursts association is usually responsible for those. You have to determine where the water's coming from. Okay. Leak detection or cause and origin reports are key in these sort of cases. If you don't know where the water's coming from, it becomes almost difficult to almost impossible to prosecute the case. You need to ask the homeowner, hey, do you have a cause and origin report? Have you hired a leak detection company? Have you hired a plumber? Oftentimes, a plumber will have gone to the property and you can tell them, okay, well, I need to see that plumber's report. The plumber's report needs to say where the water's coming from. If it's coming from a common element that belongs to the association, perfect. They are liable for those damages. Okay. Gray areas are often windows, doors, balconies, patios, pipes in the wall. You need to look to the association if it's an HOA covenants to see what they say. If it's in a condo, you need to look to the association's declaration of condominium to see what the association is responsible for maintaining. 99% of these governing documents will identify who's responsible for what. There's very little gray area once you look at the actual governing documents of the association, whether it's an HOA or a condo, the governing documents will tell you who's responsible for maintaining what. Covenant and rule enforcement disputes. These are very popular within the HOA context and sometimes the COA, but HOA is where they primarily come up. So common disputes are architectural review denials, landscaping or exterior standards, parking. I can't tell you how many cases we've had where a homeowner continues to get towed for absolutely no reason, and they have no choice other than to basically get counsel and sue the association. Pet and occupancy rules. I can't tell you how many cases I've had where homeowners had a pet for 5, 6 years. Something happens with that pet, and the association is now demanding that they get rid of the pet. And signage and flag restrictions. Okay, so these are all fall under the umbrella of enforcement disputes. Okay, what you see on the screen is the most important thing to know when fielding a call on these sort of disputes. Okay, number one, board members love to make up rules. They wake up in the morning and they think, well, what rule can I come up with today to torture my neighbors? Okay, maybe I should pass a rule that says that you can no longer park on the sidewalk, or you can no longer have a house painted gray. They can't do that. Okay, the rule must appear either one in the statute, okay, 720 or 718, or recorded in the public records in the covenants or the declaration. If it is not in there, the association probably cannot enforce that rule, okay? Oftentimes what I found is when it's not in either one of those two, the association board, came up with a new rule as they were on the board and started enforcing it, and it is a completely unenforceable rule, okay? Um, Also, oftentimes fines will arise. It's important to tell homeowners if you receive a letter in the mail saying you owe $1,000, you don't have to pay that fine. Okay, there's a statutory process under both 718 and 720. You are required to receive notice. You're required to have a hearing. And in that hearing, there must be an impartial violations committee. No one on the board, no board member's wife, no board member's husband, no board member's cousin, nobody that's roommates with a board member and lives with the board. It needs to be a truly impartial person in the community that is on that violations committee and is not simply rubber stamping whatever the board tells them to do. Okay. So as I mentioned earlier, what are the defenses in these cases? Well, you can say the rule was not properly adopted, it's vague or unevenly applied, that's selective enforcement, or there was no hearing before a fine was sent. Selective enforcement and discrimination, as I mentioned earlier, they can't apply the rule to you and not to your neighbors. That's selective enforcement. It's a little bit tricky in navigating the selective enforcement cases because as an attorney, you may ask yourself, is this an affirmative claim or is this simply a defense? The case law, if you were to look into it, is a little bit ambiguous. There is some case law out there that says you can absolutely sue for selective enforcement of a rule. There is some case law out there that says no, it's just an affirmative defense. Okay, so if you get sued by the association, then you can plead it as an affirmative defense. You'd have to look to the particular location where the property is to see the jurisdiction, to see the case law, to see whether it is or isn't an affirmative claim. But most importantly, when it comes to evidence in combating selective enforcement, you need to document it. You need to tell the homeowner, hey, you need to go ahead and take a photo of your next door neighbor's fountain, of your next door neighbor's home, and all the neighbors that have these sort of changes to their property that you are being fined for to document the selective enforcement. Okay. Also, the FHA protects against discrimination. So if you find that a homeowner is not receiving a reasonable accommodation, I see this oftentimes when it comes to homeowners trying to install ramps on their property or homeowners trying to have an emotional support animal. Those are protected by the FHA. So you can do an FHA complaint, and that can be done pro se by the homeowner, and the FHA is pretty good in handling those. Or as the attorney, you can send a demand letter to the association, letting them know, hey, this is an emotional support animal for the homeowner I represent. You are violating federal law by forcing him to get rid of his emotional support animal. We will be filing an FHA complaint, and we may be filing a federal lawsuit against the association if you don't cease and desist this sort of behavior. That letter is a very powerful letter. I can't tell you how many times I've received a call from a homeowner saying that, hey, I've had this pet for 5 years. He is my emotional support animal, and the association is trying to force me to get rid of the dog, and the association absolutely cannot do that. Okay, oftentimes the whole dispute can be resolved by sending an email or a letter, and you will look like an absolute superhero to the homeowner once the association backs off after you send that sort of letter. Protecting homeowners' rights. So what can be done from a proactive stance to protect the homeowner? Oftentimes the call that we receive as attorneys from homeowners is on the front end, before it gets to something bad. Many times it's on the back end. Many times it's right before they're getting foreclosed on, or after they've received the fine, or after a special assessment has been passed. But sometimes it's on the front end, and they're saying, hey, I'm trying to get record from the association, or I'm talking to the board members and I'm facing these sort of issues. What do you think I should do? These are basically the warning signs to alert homeowners about, okay? If you see rising assessments without explanations, that's a problem. If financial records are missing, that's a problem. If the community pool hasn't been working for a year, that's a problem. If the homeowner's telling me the board members meeting in their condominium units on a weekly basis to discuss things, that's a major red flag. And if the association is refusing to provide records, that's also a major red flag. So if the homeowner is telling you about any of these issues, where there's smoke, there's fire, so to speak. And these are oftentimes the symptoms of a deeper issue that needs to be investigated and ultimately legal action that likely needs to be taken. So look out for these sort of issues within the association context. So you're going to see here and in the next few slides, there is a playbook for handling these sort of issues with the association. It all starts with the unique tool that homeowners have, which the way I describe it to attorneys is, as a homeowner, you basically have the ability to do pre-litigation discovery. Okay, you have the ability to send out an RFP, which is a request for inspection of records. So, and you have the right as a homeowner to see everything. You have the right to see the financial statements, meeting minutes, contracts, insurance policies, bids for works, structural integrity reserve studies, of course, the declaration, a current roster of unit owners. Okay, there's almost nothing that's off the table when it comes to a records inspection. There are a few exceptions. Of course, if you ask for the emails between the board and the association general counsel, you're not going to get that. If you ask for the social security number for your neighbor, in the application that was submitted, you're not going to get that. There are things that are protected and exceptions in the rule that you can see under the statute 718 and 720. But for the most part, all the key things are open to homeowners. And unless there's a rule in the covenants or in the declaration, you can ask for this as often as you would like. I have many clients that submit written requests for records on a monthly basis. And unless your declaration or governing documents say otherwise, you can absolutely do that. You can request to see them in person. You can request that they send it to you via email. Whatever the governing documents provide is going to be the procedure for it. Nowadays, most of the time it's done electronically. However, if you'd like to go in person, you can absolutely ask the association for a date and time for an in-person inspection. The rule is a little bit outdated. It talks about photocopies. Nowadays that's not so common. You can tell the homeowner, hey, take your phone, take photos and scan using the scanning apps on your phone. That's absolutely allowed. They cannot charge you for that. The only thing they can charge you for is copies if you ask for them, but you don't really need that nowadays. You could simply take your phone, take a photo of all the things that you'd like. Or if you want to ask them to make a copy for you there, I believe they can charge you maybe 5 or 10 cents a copy, something to that extent. Okay, as I just mentioned, every association is a little bit different. Common problems we see, association will say the records don't exist. That is a major problem. The association must maintain records for 7 years under the statute, or they delay in providing records, or they charge excessive fees, or they refuse to allow photos or scanning. They have to absolutely allow this. Within the condo context, now this is only 718. This does not apply to 720. You cannot do this in an HOA. Within the condo context under 718, you can actually do ROGs, interrogatories, okay, which are called written inquiries, okay? Under 718.112, you write down your ROGs as counsel for the homeowner or as a homeowner, and you send them certified mail. The association must respond. Okay, I believe it's within 30 days. And if it requires a legal opinion of the association's general counsel, they can request an additional 30-day extension to make it 60 days. Okay, and the same fines apply for failure to provide records as they apply to written inquiries. So if they don't respond, I believe it's a $100 a day fine for up to 10 days, $1,000 fine. You can sue for the injunction. You can sue for the economic damages, which is the fine. Okay, if the association fails to respond to the records request, and in a condo, if they fail to respond to the written inquiries. I cannot stress enough how powerful of a tool this is for attorneys in this area of law. Or even if you're not in this area of law, if a client is contacting you and saying, hey, why did my assessments increase by 50%? What is the status? I don't know what the status of the roof repair project is. They've been doing this for 2 years now. I don't know what the reserve funds are. I'm concerned that assessments are going up. How much is the association spending? You can tell the homeowner, hey, you live in a condo. There are 2 things you can do to get the answers to all of these questions. Number one, you can send, or I can send for you, a request for an inspection of records. And number 2, we can ask all of these questions, and the association must respond in writing And this is going to be your primary evidence if you're forced to file a lawsuit against the association. If they didn't respond, that's evidence in and of itself. Or if they responded and truthfully, and the information is bad for the association, that's a key piece of evidence that you can use moving forward. Okay, and if they don't respond, the statute provides that the penalty is moving forward, they cannot recover attorney's fees. So now you are in the tremendously advantageous position of a one-way attorney fee dispute where you can tell the homeowner, hey, if we win, you're getting all your attorney's fees back, and if we lose, nothing happens. The status quo will be preserved. You won't be able to accomplish whatever you wanted to accomplish, but you don't have to pay the association their attorney's fees. And so we often use this strategically to kind of create somewhat of a trap for the association where we send out, prior to filing the lawsuit, the request for records, we send out the written inquiries, they don't respond, we file the lawsuit, let's say things aren't going well, now we have substantial negotiating leverage. Hey, Mr. Counsel for the association, we're going to drop our lawsuit. You may say, well, I want all my attorney's fees for having to defend this. Well, you can't get them because you didn't respond to the written inquiries that we sent, a year ago. So it is a super powerful tool. I can't stress that enough. Make sure when you're talking to any homeowner, I would say 90% of consultations that you have with a homeowner, two of the things you should be telling them, well, within the HOA, one thing, hey, have you sent out a records request for an inspection? We should definitely do that for two reasons: to get evidence and to set the trap in case they don't respond. Within the condo, same thing with records, but also add to it inquiries. Have you sent out the inquiries? No. Well, let's try to send out pre-lawsuit, essentially interrogatories, and let's gather some information. So generally, this is what a request for records looks like. You can just put the basics in there, ask what you're looking for, and the association, as I mentioned, has 10 days to respond. Board meetings, elections, and owners' participation. Okay, notice, board meetings, there must be notices. As a homeowner, you have the right to speak. I see a lot of issues with that where a homeowner attends and says, hey, I wanted to ask a question. They refuse to let me ask a question. You absolutely have the right to answer questions. Now, I have many clients that tell me they go to these meetings and they have 50 questions and they want to ask all of them and they want to scream at the board members and tell them how bad of a job they're doing. You can't do that. You have to have decorum. You have to be reasonable in the way that you ask your questions and the way you approach the situation as a homeowner. But assuming that the parties are acting reasonably, you can absolutely attend and ask questions and have a conversation with the board members. Within the election process, you have the ability to participate. Statute on 718 and in 720 are very clear on that. As long as you comply with those requirements, you should be able to be a candidate. Interestingly, an important thing to note, I always thought if you want to run for the board in a condo association, you need to live there. It's technically the only requirement is that you're above 18 years of age and you're not delinquent of assessments. So anyone here that wanted to be the board member of a building in Brickell technically can submit their candidacy and run for it unless the association's governing documents prohibit that and say that you must own. The statute is actually very ambiguous on that. Important thing to tell homeowners, because I get calls all the time from homeowners where they say, hey, this developer, he doesn't even own here anymore. He wants to be on the board. I don't know why he's doing this. This is very suspicious. Don't you have to own a unit here to be on the board? Technically, under the statute, no. Under the covenants, possibly. You would need to take a look at the covenants. Recall elections, very powerful tool for getting board members out. You need a majority of the homeowners to sign a petition for recall. If you Google condo petition for recall or HOA petition for recall, the form will pop up on Google immediately. If the board members or if the homeowner is telling you, hey, I don't like this board, I want to get them out, this is the way to do it. You need to do a petition for recall. You need to have a majority of all of the owners in the community sign. If it's a 50 or a 100 unit owner community or something near there, very possible. If you're talking about hammocks or something very big that has thousands of homes, I'd say almost impossible to do a recall under those sort of circumstances, but in the smaller communities, definitely a possibility. So think of the association like a small government. The government has to comply with the statute. The government also has to comply with contracts. So you have also rights against the government in the same way you have rights against the association. You need to use your power you need to submit the records request. You need to submit the written inquiries if you're in a condo association. So look for the early warning signs that I described earlier in the red flags. Look for the assessment disputes. Look for the fines without a hearing. Look for the records requests being ignored. Look for the foreclosure notices. Okay, gather the documents. Submit the requests for inspection of records for your client. Prepare the inquiries. No one is better at writing written inquiries than an attorney. Prepare the written inquiries for your client. You can send them for the client, or the client can send them on their own, and you can prepare them for the client if it's in a condo. But prepare the requests for inspection of records, prepare the inquiries, and you could solve almost any dispute simply by doing that. It's going to apply so much pressure to the association if they don't have a good answer to your questions, or if they don't have the documents that you're seeking. They know we have a problem. We need to figure this out and be a little bit more reasonable in the way we negotiate with this homeowner on this particular legal issue. In conclusion, to protect the homeowner's rights, you need to accomplish all the things that we discussed during this presentation. Do the inspections, request the records. Don't hesitate to enforce the homeowner's rights. Let the homeowner know you do have rights. You do have options here. You need to take advantage of them. You do not have to let the association trample your rights. Okay? So with all that being said, happy to answer any questions that you all have as it pertains to this. I know we've covered a lot of ground. I'm sure there are some very good questions out there. I'm happy to answer them.
Right. Thank you for the amazing presentation. We do have a lot of questions, about 6 questions at least in the Q&A. I just saw one pop up in the chat, so I'm going to start with the ones in the Q&A. The first question is, are cause and origin reports applicable as well to downstream or in-wall electrical issues caused by common electrical elements within the condo?
Yes, the cause and origin report will indicate where the issue began. Sometimes it's within the association common areas. And your question is consistent with a type of case we see where it's, let's say, a 5-story building. It's a roof leak, okay, and the 5th floor, 4th floor, and 3rd floor unit have water intrusion and water-related damages. You obtain a cause and origin report. It says the roof has some cracking, water spilling. The 3rd floor homeowner calls you and says, hey, I have no idea where this water is coming from. It could be the 4th floor, it could be the 5th floor, it could be the roof. I don't know where it's coming from. That cause and origin report will be Exhibit A on in your case when you present it, if you have to go to trial, to show causation, to show where the water came from, and show this is the association's responsibility. So cause and origin for downstream related damages, super important. As a matter of fact, on our end, when we represent the homeowners in these situations, we often won't even file the lawsuit until a cause and origin report is completed, because you could find yourself in the very tricky situation where, let's say you're that 3rd floor homeowner and you think, okay, well, it must be the unit upstairs. I'm not going to do any investigation. Gravity moves downward. I'm going to sue my neighbor upstairs. You sue the neighbor. The evidence comes out down the line. Actually, it wasn't the 4th floor unit. It was the 5th floor unit because of a bathtub overflow, or it was the association because of a roof leak. Well, now you're going to have to pay your 4th floor neighbor's attorney's fees for filing the lawsuit. And all of these cases under the statute have attorney's fees baked in. So you got to be very careful with that.
Right, thank you. The next question is, what are the real chances of success for a homeowner already behind by a large amount in HOA fees to qualify for a line of credit to stop a foreclosure versus proceeding with bankruptcy as an option?
So if it's a large amount, and I've seen some crazy ones where we're talking 6 figures in assessments, and it's just absolutely an insurmountable thing for the homeowner, bankruptcy absolutely will be the better option under those sort of circumstances. It may not make the issue go away. You'd have to consult with a bankruptcy attorney more so, but in my experience, as within this association context, what bankruptcy does is it creates the automatic stay. So, you want to stay in your home as long as possible and try to figure out a way to resolve the matter. Filing for bankruptcy stops the litigation, so stops attorney's fees right then and there. And then in going through the bankruptcy process, potentially it could be discharged, or part of it could be discharged. So bankruptcy, when it comes to larger amounts, may be the better option. Now, however, if you're a homeowner and you have a 500,000 plus dollar property that's valued at that amount, and you don't have any loans on the property, and all you owe is money to your association, home equity line of credit may be the better option. You know, you don't have the bankruptcy on your record, so it's kind of on a case by case basis. But for many individuals, bankruptcy is the better option, particularly for larger balances. For other individuals, when the balance is small, you may want to consider a home equity line to try to get the money and just not get foreclosed on by the association, kick the can down the road, and then focus on paying that home equity line.
All right, the next question is, can a homeowner rely on a previously granted decision by the HOA board if they relied on it to their detriment, even if it's later found that the rule was not in the covenants or other lawful policies and was arbitrarily granted?
So So if the association is enforcing a rule that is not in the statute or in the covenants, it's unenforceable. If you rely on that rule to your detriment and it causes damages to you or your unit in some way, you may have a claim against the association for having relied on that rule. Um, I haven't seen that quite often. I kind of see the inverse of that, where homeowners come to me and say, "Hey, this isn't a rule. Can the association do this? And how can I stop them from doing it, or stop them from fining me?" And and then we can pursue the matter. It's important to note in these situations, both under 720 and 718, for disputes regarding the governing documents. And well, 720, anything related to the covenants, you can't just sue. You need to send a statutory offer to mediate. The association has 20 days to respond, 90 days to mediate. Under 718-1255, there's a list of disputes where you cannot simply sue. You need to either go through the DBPR arbitration process, which I would not recommend to anyone, or send out the offer to mediate, which is a much more streamlined version of getting to court rather than DBPR arbitration, which can take months or sometimes even years. So to answer your question, if a homeowner detrimentally relied on an association that was enforcing something they shouldn't be trying to enforce, absolutely that association may be liable for any damages caused.
Right. The next question I'm going to combine with another one that is related to assessments. So the first question is, does assessment also include monthly HOA dues? And the other question that I'm combining it with is, can the HOA collect for assessments beyond 5 years?
So the assessments are the monthly dues. HOA assessments typically are the monthly dues. As I mentioned earlier, sometimes they're quarterly, sometimes they're yearly. So those are the assessments. Can they collect beyond 5 years? That's something I come across very often. Arguably, anything beyond 5 years is time barred by the statute of limitations because it would be a breach of contract claim. So failure to pay your assessments is a breach of contract. If you have assessments from 8 years ago that you didn't pay, you can argue statute of limitations. This is time barred. Now, associations have come up with very creative ways around this where they say, okay, well, that was 8 years ago, but there's been interest tacked onto that from 8 years ago. There's been attorney's fees tacked onto that. There's been late fees tacked onto that. So every single month is a new, essentially, breach. So the I'm suing you for balances from 8 years ago, but you breached it because it was due July 1st, the whole thing, and you didn't pay it July 1st. So now we're restarting the clock. It's definitely a creative argument. I would think, and it's not something that's litigated very often, but I would think it would be time barred by the statute of limitations. When we have come across it, the association has been willing to waive anything beyond 5 years. So I think the statute of limitations defeats anything beyond 5 years. The association may try to argue it using particularly that argument. And then you can use that to negotiate a better resolution for your client because there is definitely risk on both sides of that argument.
All right, I know we're almost at time. Eric, I don't know if you can stay over. I will drop the COD code
Absolutely.
in the chat. If you can stay a few more minutes, that's okay. If not, if we for whatever reason miss any questions, we'll make sure email them to me or Eric. We'll make sure that you have access to them.
Yep.
I know we still have a lot of questions in the Q&A, so I'm trying to go in order. The next
Absolutely.
one
While we
is
do that, before everybody leaves, just briefly, we take these webinars very important, and we would love your very seriously, and we would love your feedback. Things we did well, things you'd like to see done a little bit better. So if you have a moment to scan this QR code, and George is going to be sending a link to everyone as well. But if you have a moment, please scan this QR code and leave us your review of what you thought of the webinar. I really hope everyone enjoyed it. I try to give as much information and guidance as possible. There's, as I mentioned early on, a lot of issues that arise within this context, and many homeowners will reach out, I'm sure, to people that are here today. And I hope that I've given you at the very least a foundation so that you can look like like you know what you're talking about, and you can give good advice, and ultimately, look good to the client, so that in the future they consider you. And of course, if you need any additional guidance from me, please feel free to reach out to me. This is all of my contact information. This is our website. This is our general email address. This is our phone number. If you need any information at all, please feel free to reach out to me on our website. Very good resources for everyone here. We have a newsletter, and we constantly stay up to date on the changing laws. So subscribe to our newsletter. We every single month we provide any sort of changes in the law that are helpful to people dealing with these sort of disputes. We also have a blog. So if you don't find the answer to your question in the statute or in the covenants, all of in having handled thousands of these disputes, we've created blogs for these unique issues. You may find the answer to your question in our blog. We also have monthly webinars. I was just talking about it with George earlier. Next month's webinar is similar, except it's in Spanish. So if you have Spanish-speaking clients that would like to attend our webinars, we provide information, all the time on our webinars, and we are actually creating a free academic platform that we will be advertising soon in our newsletter. It's called HOA Survival School, and we'll be providing a lot of free information for attorneys and homeowners on many different types of disputes. So if you need anything, please don't hesitate to reach out to me. Check our website to gather more information. And I just wanted to inform you all of that, but happy to continue answering questions.
Great. Thank you, Eric. I know some people have to leave. I have to say that QR code, by the way, yeah, somebody was asking about the QR code. Check out the website. Make sure to subscribe to that newsletter. Like I see these emails all the time, and Eric and Michael put together some really great webinars. I know from the legal aid perspective, we have limited resources and we can't necessarily help out everybody. But these webinars are really helpful. As Eric mentioned, there's one in Spanish happening soon, so that is really powerful and helpful for a lot of the people in the community that we serve to be able to share these resources. So Eric, I'm gonna go ahead and read up a few more questions. You let me know if you have to leave at any moment.
We're good.
Let's go with the next one. And it says fantastic presentation. Agree. My question is, how does the First Amendment play into HOA law? I have a small campaign yard sign in our front yard and a friend who is running for circuit court judge. I keep waiting to get a letter. I requested the HOA docs, but wanted to know how much freedom of speech plays into all of this. Thank you so much.
So it's a little bit of a tricky question to answer. I'll start with that. So absolutely all of your constitutional rights apply within the association context. As a matter of fact, was just interviewed on the news about this the other day. There's a community out of, I believe, Palm Beach or Orlando. I want to say it's called Triumph Homeowners Association or something to that extent, where the board passed a rule saying you cannot own firearms. Obviously, a violation of the right to bear arms. Um, the homeowners reported it to the Attorney General. The Attorney General sent a scathing email to the board of that association and informed them, hey, this is a constitutional right. I don't care what your covenants say or what you're trying to get them to say. You have an absolute constitutional right to this. So same thing applies to the First Amendment. You have a constitutional right to freedom of speech. You can say whatever you want to say, barring the exceptions of causing danger in the community or anything like that. Every association covenant, every association declaration has a provision you have to be very careful with. It's the nuisance clause, okay? that provision is essentially the provision that's used to silence homeowners. They will say, well, the homeowner's saying that or is saying negative things about the board. This is creating a nuisance in the community, and we're going to sue you for that. Okay. The response to that would be exactly what we're talking about here. Well, I have a First Amendment right. If you sue me for that, I'm going to countersue you for what's known as a slap suit. And that's within the association context for both 720 and 718 written in the statute. If an association sues you essentially to silence you, you can sue them back under the slap statute in both of those. So you have the right, but it gets a little bit tricky because associations do sometimes get nasty with homeowners and start to fight them and threaten a nuisance lawsuit against them.
All right. The next question is, if an HOA and the bank are both foreclosing, how do those cases interact? Is the bank or HOA deemed an indispensable party in any foreclosure action? And what is the best way to represent the homeowner when there may not be enough equity to pay the bank, less HOA assessments?
So oftentimes those are filed separately. I have not seen that argument of indispensable parties. However, the association knows at the end of the day, the bank has priority. So what I've seen happen many times is the association will foreclose first. Usually the banks move a little bit slower. The association will foreclose first, take the unit, rent it out as long as they can to try to get their money back. And then eventually the bank will foreclose on their interest and then sell it at a foreclosure sale. And then whoever buys it at that foreclosure sale will ultimately have it free and clear. But the order of priority is bank is number one, associations number two, and basically there is no requirement for all of them to sue together. Sometimes that does happen where they all sue together, meaning the bank names the association and the homeowner. But most of the time, the association will foreclose first, and then the bank will foreclose when there's two liens on the property. As it pertains to what a homeowner can do when they don't have the money, really the only defense, much like an eviction, is just to delay, to try to keep your home as long as possible. If you can sell it to get as much money back as you can to avoid the foreclosure, you can do that. If you can get as I mentioned earlier, a home equity line, you can do that. There are very, very few defenses. The only one I've seen used effectively is violation of the Fair Debt Collection Practices Act. If the association is doing some really egregious stuff that's violating the statute, the way I've seen it is they start, inventing charges. I saw the other day, property manager on a ledger charged for, I believe, I forget exactly, but it was something to the extent of, there's line items, interest, late fees, attorney's fees, principal. And then one of the line items was office rent or something to that extent. Obviously the property manager cannot charge a homeowner for office rent on an assessment foreclosure case. That's a spectacular Fair Debt Collection Practices action that you'll have against that property manager. So you have to look at the ledger, not a ton of defenses. The association or property manager have to be really getting carried away, and then you could sue them under the FDCPA.
All right. The next question is, when a homeowner is fined, who gets the money? Does it go to the reserves for the community, or does the association company as an incentive?
I've not seen it used as an incentive for the management company for fines. Assessments are another story. I've seen incentives for those. For fines, usually it goes directly into the operating budget of the association. The property manager should not be touching that. So I've not seen it used as an incentive like that.
All right. For fines requiring notice, hearing, or hearing before implementation, does that include non-payment of an increase of monthly dues?
No, that would be considered an assessment issue. Fines are when there's a violation of the covenants and they can demand $100 a day up to 10 days of $1,000. I've seen associations play crazy games with that where they say, oh, this fine is part of the assessment, so I'm going to foreclose on this fine. And that is not the way it works. Assessments and fines are two totally different things, barring some very unique language in the covenants that says that the fine can become an assessment on the property, which I have seen. very rarely, but I have seen it. But barring that sort of language, it should not be treated that way. The only context you can foreclose for a fine on is in an HOA. So in a condo, you cannot foreclose on a fine. In an HOA, you can foreclose on a fine. I believe the statute says it must be $1,000 or more. So let's say you had, you know, patio furniture on the balcony that wasn't improved, and the association sent you a letter and it was there for 2 days. Okay, and then they sent you, you know, a letter saying you owe or in an HOA, let's say, 'cause it's not in a condo. In an HOA, you had patio furniture on your front lawn that the association did not approve. You left it there for 2 days. On the third day, you removed it. They send you a $200 fine, which would be the maximum of $100 a day for 2 days, $200. They cannot foreclose on that. It must be $1,000 or more, and it must be an HOA. Otherwise, the most they could do is temporarily suspend your access to the common areas. So if you're in a condo, you can't use the community pool or gym for a couple months. You know, in an HOA, if it's less than 1,000, pretty much the same thing.
Right, there are technically two questions left because there are three, but two of them are related. So the question is, the condo bylaws restrict ownership to 2 units out of 8 total units. One owner owns 2 units under their name directly and 2 other units via a trust where they are the beneficial owner. Can we force them to release ownership of 2 additional units? Because this is causing a disbalance in voting in the condo
Mm.
where the owner dominates the vote.
Wow. Okay, that's a very tricky one. I mean, I would say technically it's a different entity that owns the unit. The board may want to push to amend the governing documents to say whether you are the sole owner or the owner of an entity that owns a unit, you can't have more than two. It's going to be very factually specific to what the covenants say. But you know, much like, you know, let's say me, Erik Perez, and you know, there's me, and then there's my law firm, Perez Mayoral, and let's say there's a restriction of the 2 units. I could own 2 units, and then Perez Mayoral could own 2 units. And I think they can make the credible argument that, hey, I only own two. Those other two are owned by that law firm. I know I own the law firm, but those are owned by a completely different entity. You know, conversely, the other side would argue, well, you're the owner, so you're essentially, you know, de facto the owner of the 4 units. So unique situation, I would say it depends on specifically the language in the covenants, and um, potentially the board may want to amend to make it more specific to say you can't own individually or be the owner of a corporation that owns any more than 2 units.
Right. And the last question, if there was a previous lawsuit that was dismissed, may the HOA still collect attorney's fees from that previous lawsuit in the next lawsuit? This is common in cases that involve delinquent regular HOA fees.
So if you're talking about deficiency judgments, yes, the association can foreclose on the homeowner. Let's say they owed $50,000 at the foreclosure sale. The property sold for $30,000. There's a $20,000 deficiency. The association can continue to go after you. Oftentimes, that's pled as a separate count number two. And the association absolutely can go after you for that deficiency, even though you've already been foreclosed on, moved out, and all of that stuff, and try to obtain a deficiency judgment. I've also seen situations where, you know, Miami, not uncommon to have cash buyers of property. And I've seen situations where there's a cash buyer, closes on the property, the assessments do not get taken care of. That cash buyer inherits the balance on assessments that the prior owner had, and can absolutely be foreclosed on for failing to handle that at the closing. So yeah, absolutely.
I want to clarify the questions because I think what they meant with the question was initial for let's say they were behind, the initial foreclosure was dismissed, whether maybe it was paid, maybe it wasn't dismissed for other reasons, maybe it was voluntarily dismissed. And then eventually they file another foreclosure for additional fees. Can they tack on those attorney's fees from the previous lawsuit? Like almost like piggybacking on, let's
Oh,
say, let's
okay,
try to get
okay.
these fees.
Oh, well,
Yeah.
if it was dismissed, I would have to assume that there was some sort of settlement agreement with release language. So I would think that all attorney's fees, interest, late fees, costs, and all that are handled by the release. I can't think of any other reason an association would just voluntarily dismiss or a lawsuit would be dismissed for assessments other than a settlement. Um, if it was on the off chance inadvertently dismissed by the association, can they continue to go for those attorney's fees? I would say yes. They can continue to go for those attorney's fees unless it was dismissed with prejudice for some reason.
All right, so we're like 15 minutes over the allotted time. So Erik, I wanted to thank you again for this amazing presentation. I think it was very much needed for us in the legal aid community. If anybody has any additional questions, feel free to email them to me and I'll make sure Erik gets them. I know the information for Erik is also going to be available in the materials. So I wanted to thank everybody for joining us today, for being patient because I know we went over time, but I'm pretty sure, Erik, that we could just keep going on and on and on, and there would be an endless amount of questions. So again, thank you so much for taking your time to share all of your expertise and knowledge with us. And we look forward to future webinars and to collaborating for you. Thank you, Erik.
Absolutely. It was a pleasure. Thank you so much. Take care, everyone. Have a great weekend.